Welcome to Obtaining a Patent Part 1, brought to you by PNC IP Group. Many people and businesses new to the world of intellectual property often wonder what's involved in obtaining a patent. While there's a lot of information to digest, this presentation focuses on what people can expect in terms of dealing with the Government Patent and Trademark Office, and in this specific case, the Canadian Intellectual Property Office. First and most important to understand is that in the world of patents, just because you applied doesn't mean you get. In other words, filing an application is only the beginning step to obtaining a patent grant. So what happens after your patent application is filed? Upon receipt, the Canadian Intellectual Property Office, or what we call CIPO for short, reviews your application to ensure a number of formality requirements are met and that your application is consistent with the Canadian Patent Act and patent rules. In particular, your application needs to have a title, a description appearing to describe an invention, and ultimately a set of claims, which means wording that describes the invention to which you claim an exclusive set of rights. Where CIPO is satisfied that a number of basic formalities are met, CIPO will issue an official serial number in a document referred to as a filing certificate. The filing certificate sets out basic information such as the name of the applicant or applicants, the name of the inventor or the inventors, the title of the invention, the date the certificate is issued, an official serial number for the application, a file reference number if that's applicable, the official filing date, which means the date on which CIPO considers all basic formality requirements were met, and the expected date upon which the application will be laid open for public inspection. That means the date that the application will be published so as to be accessible by the general public on the CIPO patent database. The filing certificate will also explain that in order to maintain the application in effect, it will be necessary for you to pay maintenance fees to CIPO commencing on the second anniversary of the official filing date and annually thereafter, up to a maximum of the 20th anniversary, which is of course the maximum lifespan of the patent grant. At some time between when the application is filed and up to a maximum of 4 years after the official filing date, it will also be necessary to request examination. Requesting examination means that an applicant is asking for and paying the relevant fees for CIPO to examine and review the filed application to make a determination of patentability. If examination is not requested within that 4-year period, the application may become abandoned. There is a reinstatement mechanism, but with recent changes in rules and legislation, reinstatement has become much more difficult than prior to 2019. Once CIPO receives a request for examination, along with the examination fee, the subject application is then entered into a queue. The application is examined in turn as compared to all other received applications. During examination, CIPO will search not only the Canadian Patent Database, but various patent databases from around the world, as well as publicly available trade and technical publications. The search conducted by CIPO is an attempt to find out if there is previously published information sufficient in detail such that there is an enabling disclosure prior to the official filing date of the subject application. In other words, CIPO wants to find out if the application that was filed contains new, inventive subject matter that is patentable, or merely repeats subject matter previously disclosed to the public and so is not patentable. Apart from trying to determine whether the application contains new subject matter, CIPO will also try to determine whether the application discloses an inventive step. An application that discloses an inventive step is patentable, whereas an application that fails to disclose an inventive step, or is otherwise considered obvious, is not patentable. When the search and review is complete, CIPO will issue to the applicant or the applicant's agent correspondence referred to as an office action. The office action outlines CIPO's position on whether the subject application is patentable or not. In the vast majority of cases, CIPO takes a position that applications, as filed, are not patentable, and in so doing, lay out a case for their position. CIPO will cite all of the relevant prior art they've uncovered, describe what's in the prior art, and then attempt to link what's in the prior art to what is disclosed in the application. Why does CIPO take a position that the application is not patentable? As a policy, the Patent and Trademark Office are required to be conservative as to what is eligible for patent protection, essentially a 20-year monopoly. By heavily scrutinizing each application, CIPO ensures that if a patent does ultimately issue, the patentee thereby receives an instrument reasonably broad and clear in terms of the scope of protection they are entitled to, as opposed to granting patents for pretty much anything which would in turn render patents worthless in terms of scope of protection. Upon receipt of the office action, the applicant or the applicant's agent receives up to 4 months to formulate arguments against the examiner's position. In other words, argue why the examiner is wrong and why the subject application is in fact patentable. The job of the patent agent is to essentially argue with the examiner by forming and submitting a coherent set of written arguments to clearly identify one or more patentable aspects not disclosed in the prior art or otherwise described by the examiner. Unlike the United States and certain other countries, one benefit of filing an application in Canada is that an applicant or their agent can have more than one attempt at trying to convince an examiner of patentability. Ultimately, if the examiner is persuaded that the subject application contains patentable claims, then the examiner will eventually issue an allowance notice, typically titled Commissioner's Notice, Application Found Allowable. The Commissioner's Notice will contain information such as the date of the notice, the application serial number, the agent's corresponding file number, a due date, and a description of any final fees due. The Commissioner's Notice will also reference the application's filing date, the name of the applicant, the name of the inventor, the application title, the number of claims, and the latest date the application was examined. The Commissioner's Notice will also lay out instructions for payment of final fees in order for the application to proceed to grant, as well as the consequences of failure to pay those fees. Once the final fees are paid and the application is granted as a patent, all that remains to maintain a patent in force is to continually pay the annual maintenance fees until the patent term expires. That concludes this article. Thank you for listening, and as always, if you have any questions, always feel free to call us. My name is Tapas Payne. My telephone number is 905-303-8542, extension 221, and I welcome your calls anytime. I look forward to hearing from you. Thank you, and we'll see you next time.